What's up, everybody? We've got some new Kohberger documents coming in. We're going to jump right to them. It is the media's response to Kohberger's attempt to block cameras, get rid of the cameras, accusing the media of breaking the rules, and they want to respond. They do so in writing form here, but they also want to make their oral arguments at the hearing. They want to be there before the judge makes any decisions. And the best way for them to do that is to show up at the hearing and make sure that they have an opportunity to be heard. But all of this is happening right now. All of this is happening very quickly. So they think there's almost no way for them to be ready in time for the already scheduled hearing. So what do? First, they file a motion to continue the hearing, where it simply says the proposed interveners, which is the media conglomerate, move the court for an order continuing the September 1st hearing date on defendant Brian C. Kohberger's motion to remove cameras from the courtroom. Proposed interveners separately are moving to intervene for the limited purpose of opposing Mr. Kohberger's motion. The motion was filed August 24th, 2023, with a hearing set 8 days later. Although proposed interveners are responding as quickly as they can, counsel for proposed interveners will be out of town on September 1st, 2023 for a long scheduled travel. Proposed interveners also seek additional time to fully respond to Mr. Kohberger's motion. Accordingly, proposed interveners seek a continuance of at least 1 week to a date convenient to the court and the parties. To me, this is a reasonable request. Okay, regardless of if they're on vacation or whatever the reason is, they should be able to be heard. Their rights are at stake here as well. Follow the podcast, Trial by Media. The media also has rights. We are going to be doing their rights very soon and dropping that on the Lawyer You Know podcast channel. But they have a right to be there. Wendy Olson sounds like she's going to be on vacation, long scheduled ahead of time. But even if she wasn't, August 24th, it was filed. They need time to respond. They did not know it was coming. Maybe they did know it was coming, but I think they can at least argue we didn't know this motion was coming, and therefore they need an opportunity to respond, to do their research and respond and be there at the hearing to argue their case. All right. Before we get to the motion to intervene, take a second, hit that like button, subscribe to our page, do all of the YouTube things, because we are going to look into this document, see what articles they reference, see what arguments they make as to why cameras should be there and how the media did not, in fact, break the rules. All right, so let's pull that up. Make a note to myself. All right, here we go. That is the wrong one. Let's get rid of that and pull up the right one. All right, motion to intervene. Here we go. On June 23rd, this court entered an order allowing 20 media outlets with the Associated Press as the lead media outlet to intervene in this case for the limited purpose of challenging the then in place amended non-dissemination order. We all remember that. We were there for that. We read it. We reviewed it. Granting the motion to intervene for limited purposes at 1-2. A nearly identical media coalition at this time, consisting of 13 outlets again, I don't know what outlets, again seeks to intervene. This time for the limited purpose of opposing Brian C. Kohberger's motion to remove cameras from the courtroom, filed August 24, 2023, and currently set for hearing on September 1st, 2023. And for any other proceedings affecting media access to the proceedings, including whether cameras will be allowed in the courtroom at trial. So what are they doing? They are jumping in specifically to respond to and fight against Brian Kohberger's motion to remove cameras. So let's read their argument. Now, they also said they want more time to make a better argument, do more research, but with the limited time, they filed this on, I think, August 30th. Is that right? Yeah, August 30th. So they got it on August 24th. There was a weekend there. They turned it around as quick as they could. They wanted to respond before the September 1st hearing because they'd rather at least have some argument in there before the judge has the hearing if the judge were to deny their motion to continue that hearing. But if the judge grants their motion to continue that hearing, then they want to be heard and they may make further written argument, which I would expect. The Idaho Supreme Court in the Associated Press versus 2nd Judicial District made clear that even absent a specific rule in Idaho, intervention by the media on a limited basis is appropriate to defend the public's right to access and free speech. Here, intervention is particularly appropriate where the court previously sought input from the media coalition regarding cameras in the courtroom, but ultimately reserved ruling given the high-profile nature of this case, the public interest in watching what is happening in the courtroom, and Kohberger's fundamental rights to a fair trial by an impartial jury. Order reserving ruling on the issue of cameras in the courtroom. So we knew this was coming. We have already heard arguments about this. I just realized I had it on the wrong setup. So we knew this was coming. The judge reserved ruling. Now it seems like the rubber is meeting the road. Speedy trial has been waived. It is not happening in 4 or 5 weeks. But now we need to get to a decision on cameras in the courtroom. Kohberger is forcing the judge's hand. The media would have just let it ride as long as they could because status quo at this point was they were allowed to have cameras in the courtroom. Media was allowed to report. Their rights were being protected, so they weren't really worried about it. They weren't going to, push this. But Kohberger's team at this point feels like, Judge, you got to make a call. And we think the only way to protect his right to a fair trial and impartial jury is to make the call to ban the cameras. The media says, whoa, not so fast. Mr. Kohberger asked this court to remove cameras in the courtroom on the grounds that the media have failed to heed the court's admonishment, not to focus strictly on Mr. Kohberger, and to show a wide shot of the courtroom if they wish to continue filming court proceedings live. Mr. Kohberger's subsequent citations to various media and social media publications do not support his position, however. For example, Mr. Kohberger cites to a Fox News article that describes the court's statement to photographers and camera persons that they should not focus exclusively on Mr. Kohberger. The Fox News story does not focus strictly on Mr. Kohberger. However, it includes photos of A, Mr. Kohberger and defense counsel Jay Logsdon entering the courtroom, B, defense counsel Ann Taylor and Alyssa Massath entering the courtroom, C, Latah County prosecuting attorney Bill Thompson in the courtroom, D, the murder victims, E, Mr. Kohberger entering the courtroom, and F, a still photo from the video of an Indiana law enforcement stop of the vehicle Mr. Kohberger and his father were in on December 15, 2022. See Exhibit A attached. So let's jump down there because it's not actually sealed. We get to see an exhibit. And here's the exhibit where it clearly shows more than just focusing on Mr. Kohberger. Here's Jay Logsdon. Here's Ann Taylor and Alyssa. Here's Bill Thompson. Here's the victims. Here's Kohberger again. Oh, they didn't mention this one. Oh, actually, I think they may have mentioned it with the deputy. And then, of course, Kohberger's dad and him from the car. Okay. So not solely focusing on Mr. Kohberger. In addition, although Mr. Kohberger argues that he is entitled to defend himself against capital charges without cameras focused on his fly motion at 5, that assertion misstates the role that courtroom camera coverage played in the X, formerly Twitter, social media post that appears at page 3 of his motion. No photographs or camera footage focused on Mr. Kohberger's fly. Rather, one random X user modified a photo showing Mr. Kohberger and a deputy entering the courtroom by cropping it into a very small size, focusing on his belt, and adding a reference to Mr. Kohberger's fly. Motion at 3. Even the crop photo itself does not focus on Mr. Kohberger's fly. What are we doing? Like, why is this in like X, formerly as Twitter? We've got some of that in here. We've got fly jokes. We've got random Twitter users or X users, as they say, who I'm sure is just enjoying the potatoes out of this. That random one X user. I wonder if he watches The Lawyer You Know. If he does, that would be funny. So go ahead and drop a comment if you are the one random Twitter user that modified the photo. I guess zooming in is technically modification, but I don't think they're arguing that his fly was not down. But this is what we're literally arguing about because the defense wants to say if people are arguing about his fly, it doesn't give him a fair trial. The media is going to say people are going to do stuff like that with the camera and the footage and the pictures that are already out there about him, about his eyebrows, about his hair, about cuts on his face, whatever it is. They're going to find something. They're going to make posts about it. That's not going to end that. But what it does do is cut off the media's rights. What it does do is cut off public access. What it does do is cut off transparency. Are we going to cut all of that off just to make sure somebody doesn't make a joke about his fly being afraid of heights? That's the question. And a broader view of media coalition stories following this court's June 27, 2023 statement shows the media coalition participants and other longtime media outlets have followed the court's direction. For example, a KTVB story covering the August 23rd, 2023 hearing showed a variety of camera shots, including a broad shot that showed the entire courtroom, both counsel tables and the bench, a close-up of the judge, a slightly zoomed-in shot of Mr. Kohberger and his counsel in which the Zoom feed also could be seen, still shots of the victims, and an interview of a legal analyst. There's the link. An ABC News coverage on Good Morning America in August showed a variety of shots of the courtroom and the defendant with still photos and stock footage of earlier developments in the case. The coverage also provided balanced coverage of the state's and Mr. Kohberger's positions on the motion before the court. These stories did not focus exclusively on footage or close-ups of Mr. Kohberger. I think we're going to click those. Let's see what these are. Does this come up for you? Okay, it does. Idaho murder suspect Bryan Kohberger waives his right to speedy trial. Okay. And then it's just a video of it. How long is the video? There's ads. All right. So the reason we're going to look at this is they're referencing these, and I've actually seen lawyers reference things, and what they say they are is not actually what they are, which is always bad. Okay. We can skip the ad. And so it's 2 minutes. Let's just watch.
To push his trial back. The man accused of murdering 4 University of Idaho students was in a Latah County courtroom for a status hearing this afternoon. And Abby Davis has more information about a quick, but it was a very busy hearing today, Abby.
Yeah, well, not only will the trial happen later than originally expected, Kohberger's team also announced 2 more motions they plan on filing.
Sure you want to do this? Absolutely.
Bryan Kohberger waived his right to a speedy trial Wednesday afternoon, pushing his trial.
So far, fair coverage, just reporting what happened. Also, we see the judge, we see everybody, we see Kohberger and Ann Taylor, nothing focused in on him, which is why they picked this clip most likely.
Back indefinitely. Kohberger is accused of stabbing 4 University of Idaho students to death last fall. His defense team said during the status hearing, they need more time to prepare for a trial, and that an October 2nd start date is too soon.
Our investigation is not complete.
All stuff we've already watched together, but we can see it again here.
Kohberger's decision didn't surprise former Idaho Attorney General Dave Leroy.
Well, it's fairly predictable that the defense was going to need more time to consider, to rebut, to get their own.
They get their legal analyst to discuss the defense's position, not condemning them, just kind of explaining what it is.
Experts on a lot of this complicated scientific testimony with regard to DNA, with regard to cell phone tracking, probably with regard to internet communications back and forth.
Kaylee Gonzalez's family also wasn't surprised. Kaylee is one of the 4 students murdered. Shannon Gray, the Gonzalez family attorney, said in a statement, the family wants the trial to happen as soon as possible, but understands it may need to be delayed for both sides to be fully prepared.
So they give the family's position, nothing wrong with that. Explaining it, putting together a pretty good news clip here in 2 minutes and 44 seconds, I think. Legal analyst, the lawyer for the victims, seems pretty well put together.
Are a couple of things I need to place on the record.
During the hearing, Kohberger's defense team announced they'll ask for the death penalty to be taken off the table. They also plan on filing a motion to ban cameras in the courtroom.
Hearing motions to limit cameras in the courtroom is becoming more and more common because judges need to, in this media age, control their courtrooms.
Judge John Judge said they'll likely schedule Kohberger's trial after his next status hearing on September 1st. Judge Judge will consider the defense's request to dismiss Kohberger's grand jury indictment during next Friday's hearing. The defense or prosecution can also ask for the trial to be moved to another county because, remember, they'll need to find a fair and impartial jury. And of course, we have a full summary of today's hearing on our website, ktvb.com.
And we don't know when Judge will expect to hear, or I should say, rule on any of these requests that the defense made.
Yeah, we're expecting those motions to be filed likely tomorrow.
Okay. Thanks, Abby.
So back to the document here. So we saw that one. Let's take a look at the other one that they referenced. So again, their explanation of it was, they saw these different shots, which is correct. Then ABC News coverage on Good Morning America in August showed a variety of shots of the courtroom, still shots, stock photos. The coverage also provided balanced coverage of the state's and Mr. Kohberger's position. All right, let's take a look at that. First, we got a tweet. Oh, Page doesn't exist. Okay. So then we will go to the next link here. The Good Morning America video. Let's take a look at what this is, see if it's fair and balanced, as they say, and if the use of it was proper. Because I mean, that's really what this comes down to. These are the clippings. Now listen, in case you're wondering how lawyers work, they like to find stuff that's good for them and present it to the judge. So Kohberger's team presents things they think are misuse of the media and the way things media did wrong and the jokes that are being made and the things that are being said and the biased reporting, which I mean, some of it is biased, some of it is slanted, some of it is unfair, some of it is not balanced, right? And I think that that is totally fair for Kohberger and his team to point out. So the media on the other side is saying, well, hold on a second. We're going to point out where it's good. We're going to point out where there aren't issues. We're going to point out why this is good to have transparency so that the public can understand what's going on. And that's what they're doing here. Each side gets their fair opportunity to argue their points in the case.
College students appearing in court. Attorneys for Bryan Kohberger making requests to the prosecution and a judge weighing in. ABC's Faith Abube has more on these developments. Good morning, Faith.
Good morning to you, Janae. Loved ones with one of the murder victims were inside that courtroom as defense attorneys tried to cast doubt on the evidence against Bryan Kohberger. In the meantime, though, the suspect himself out of his orange jail jumpsuit, showing very little emotion in that hearing. Quadruple murder suspect Bryan Kohberger.
So I think some people would have a problem with some of those characterizations on Kohberger's team, but let's keep listening.
Wearing a tie and a blazer, entering an Idaho courtroom Friday for the first time since June. All right. His defense lawyers requesting a pause on the case for more time to review additional evidence and demanding state prosecutors release all details about the investigation into DNA samples they say put Kohberger directly at the crime scene.
Again, all things we know, but we just want to see how it's presented on here, right? We want to see how Good Morning America presented it. Was it fair and balanced? Were they doing anything wrong, crossing any lines? Now, the problem is these are a 5-minute and 3-minute clip. How much are we really going to get from that? That's the problem versus, you know, a random Twitter user, as they say, posting something that they're calling inappropriate. Again, both sides using clippings that are beneficial to them. And that's what a judge is for, to parse it out, figure out the truth, figure out what's best for this case.
On a knife sheath underneath Madison Mogan, one of the 4 University of Idaho students, they say he stabbed to death in an off-campus house back in November. The defense trying to cast doubt, pushing the state to disclose the materials they used during the genetic genealogy investigation, accusing them of not turning over lab results related to 3 unidentified male DNA samples found at the scene.
At this point, all I'm hearing is speculation.
With just 6 weeks left before the trial, the defense hoped the experts would compel the judge to side with their request for more discovery.
It's essential for the attorney to know, for a number of reasons, about the details of the testing and the investigation.
Police allege they zeroed in on Kohberger using DNA, cell phone data, and a white Hyundai Elantra spotted near the crime scene, similar to Kohberger's vehicle. Earlier this month, Kohberger's attorneys were compelled to give an alibi to explain their client's whereabouts during the murders, saying in part, quote, Mr. Kohberger has had a long habit of going for drives alone. Often he would go for drives at night. But the prosecution is calling.
Again, I don't see any problem with they were compelled to give an alibi. Here's the quote from how they gave the alibi. I don't see any issue with that.
Calling it a vague alibi, asking the defense whether they intend to provide more corroborating information. Meanwhile, Kaylee Gonzalez's father, eager to see justice.
Today was the first time it felt like things were actually being hashed out and we were making progress towards a solution of truth.
And Janae, the judge in this case previously entered a not guilty plea on behalf of Bryan Kohberger, but his defense attorneys want the entire case thrown out, arguing that the grand jury process was flawed. Janae?
Yeah, even questioning the jury selection process. Faith, thank you. For a deeper look now at this story, we're joined by Shauna Lloyd, an ABC News legal contributor and managing partner for the Cochran firm. Shauna, thank you so much for being with us this morning. How critical is the DNA evidence in this case?
Janae, the DNA evidence
liability
PS quit some was due place how the judge
defense also requested.
No disrespect to this DNA expert. We've just heard so much of it and read so much of why the DNA evidence is important, why it's not. We'll wait for the judge to make a determination. But again, fair game for an interview like this. I'll play the end to see if anything else is said at the end.
While still getting additional time for the things they need. The judge has determined that that is not going to happen. The case is going forward. So if the defense wants additional time, they are going to have to waive speedy trial.
And this is all old before the speedy trial. This is just an example of articles using the media appropriately is what the media coalition is trying to do in this motion.
And the judge saying clearly we are 6 weeks away from trial. Shauna Lloyd, thank you so much for being with us.
All right. So that's it. So I don't see any issues. Obviously, these are going to be the ones they pick and reference. They're going to be some of the best ones. And if I'm the defense, I'm going to argue, oh, they picked 2 vanilla news videos and articles, but I think the defense is going to be able to present a lot that are slanted, that are convicting him in the court of public opinion. But I think the media coalition could be like, there are ones on both sides, Judge. And I think they'd be able to find some that are saying Kohberger's innocent. He didn't do it. It was somebody else. They're going to find some that say Kohberger absolutely did it. He's guilty. Can't wait for him to get convicted. And then they may even find some that are balanced. So I do think there are videos and things coming out on both sides, some that are balanced. But I do say, if I had to guess, the majority are on the convicting Kohberger early. But again, that's kind of how a public trial works. That's how publicity works. The question is it going too far in this case? And that's what the judge has to determine after looking at what the media and the defense presents to him. Finally, many of the outlets who seek to intervene have significant experience broadcasting live courtroom proceedings, including in high-profile trials that resulted in both acquittals, Wisconsin v. Kyle Rittenhouse, Ohio v. Skylar Richardson. You could throw, just off the top of our head, Scott Peterson in there, and convictions. South Carolina v. Alec Murdaugh and Letitia Stalk, just off the top of our head, right? So we know that these media outlets, I like this argument. It's like, Judge, we have had cases like this with political backings, with people that were very angry, with a lot of passion, a lot of argument on both sides. We've done it before. We've live broadcasted it before, and we've gotten results on both sides. It's not like every high-profile case that we cover ends up in a conviction. I like how they decided to throw 2 acquittals and 1 conviction on there. I think we can probably list out a lot more convictions like Ronnie O'Neill, Theodore Edgecombe. I mean, I would say it's predominantly convictions, but guess what? The criminal justice system is predominantly convictions. So that would be an interesting study. The media should do a study. Is there a difference in percentage of guilty verdicts? And is there a difference between guilty verdicts generally in the criminal justice system and ones that have media coverage and that are high profile cases? Does that percentage change? Is it a higher percentage of convictions? Is it a lower percentage of convictions? That's the question. So, I mean, that's a question that I think would be interesting to be answered by the media. And I think that's really great evidence in their favor if the percentage does not actually change, or if it's better. I shouldn't say better. If there are more acquittals, then the defense can't really argue that it's bad for them or prejudicial. But if I was if I was Brian Kohberger's team, I would say, yeah, Judge, but this case is specific. Every case is very different. And the way it's being reported here, the predominant guilty verdicts in the court of public opinion are affecting this case. It's in a small town. It's very different than all those other cases, and you want to differentiate. If the data is good for you, you want to differentiate. If precedent's good for you, if the data is bad for you, you differentiate. If the precedent's bad for you, you differentiate. If it's good for you, you give all the analogies, you connect it, you show how it's the same. That's how the legal arguments work. Their camera equipment and operators are experienced and not the large, clunky, numerous camera equipment and operators that the Supreme Court expressed concern about in Estes v. State of Texas. In Estes, there were at least 12 camera operators in the courtroom for a pretrial hearing, and the equipment journalists used was noisy, requires cables lying around the courtroom, and at trial involved some new newsreel style cameras, meaning Pete talked about this, I think, on our podcast. It was bulky. It was distracting. There were wires everywhere. Everybody was looking at the cameras. That's not as much as what it is now. They fade into the background. People barely notice the cameras and the microphones anymore. So it's not the same as some of these old cases that they're trying to rely on to get the cameras out of the courtroom because they caused problems. They do not cause the same problems today, is the argument the media is making. And they're proving it by saying, we've got a lot of experience. We've done it in these other cases. Here's how we do it now versus how they did it then. The court can take judicial notice that similar equipment is not involved here. Plainly, the Supreme Court's concerns in Estes do not require removal of the more modest, less intrusive camera equipment being used by reporters in this case. Accordingly, the media coalition seeks to intervene for the limited purpose of opposing Mr. Kohberger's motion to remove cameras from the courtroom and to make full argument and briefing on this issue, meaning they want to argue it more. They want to brief it more. They want to do more research. Maybe they're going to bring in some data of the results of high-profile cases. It wouldn't be that hard. There's not that many of them. And if it's a small sample size, maybe the percentages work out better for you. Maybe they can say something like 25% of the high-profile cases that we live stream come back with acquittals, and only 11% of regular cases do. I don't know what the answer is, but they might need more time to put data together like that. And that's why we looked at that other motion. The motion to continue this hearing is important because if the judge does continue it a week, it allows them more time to brief the issue, more time to do research, more time to make arguments, and more time to prepare for their oral argument in that future hearing. And it seems like Wendy Olson, assuming, because she's the one I believe that made the arguments last time, is going to be out of town. She would like to make the arguments, or they would like her to be the lawyer to make their arguments. And if they do it on September 8th, that would be much more likely. So here's what I need from you. I need you all to tell me what you think. After looking at these two news clippings that they chose, does it change your opinion on whether or not cameras should be in the courtroom? I know a lot of you think, I think the majority think cameras should be in the courtroom, and that's fine. Do you think the media should be involved in this at all? Or should the judge just listen to the parties and make a decision? Should the media be allowed to intervene? What do you think of their rights? What do you think their rights are? That's really what I want to hear from you in the comments so I can get a feel for how the public, because this is really about public access, all of you, being able to watch this, being able to understand and learn about this process, being able to see if this process is fair. And if it's not, call it out and make sure we are all protected by the rules we live under and we choose to live under as we choose to live in this country. And I think that's all really, really important. So I want to know your thoughts on it as members of the public, as mostly citizens of this country, or at least the majority of people watching. And even if you're not, let me know what you think about it. All right, that's all we got for a doubleheader today. Hit that like button and please make sure you subscribe before you leave the video. If you want to hear what I actually do as a day job and full-time job, stick around for the outro as we explain it. I'd love to hear from you if you ever need my help on a case. If anybody you know or yourself becomes injured, somebody else's fault, if there's a wrongful death case, car accident, whatever it may be, give us a call, reach out. We'd love to talk to you about it and see if we can help you. But for this video, that's all we've got. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to The Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.